Welcome to A Digital Divide, Bridging New Technologies and Traditional Evidence Standards, Are Changes Needed? My name is Michelle Peterson. I am the chair of the Magistrate Judge Education Committee, which is the sponsor of this presentation. The Magistrate Judges Education Committee tries to every year provide programming that is relevant to all our judges and lawyers in the Ninth Circuit, and I think we've succeeded in that today. I would like to briefly introduce the panel. In your materials, you have a much more detailed bios, so I encourage you to look at those bios. First, we have Judge Goddard, who's standing here next to me. Judge Goddard, Allison Goddard, is a magistrate judge in the Southern District of California, where she has served since 2019. Many of you have heard Judge Goddard speak on the emerging issues regarding artificial intelligence, and she is a self-taught expert in the field. Next, we have Professor Daniel Capra. Professor Capra is the Reed Professor of Law at Fordham Law School, and as relevant here, he has served as the reporter to the Judicial Conference Advisory Committee on the Federal Rules of Evidence since 1996. Next to Professor Capra, we have Professor Mara Grossman. She is a research professor at the School of Computer Science at the University of Waterloo and an affiliate faculty member at the Vector Institute of Artificial Intelligence in Ontario, Canada. She focuses much of her scholarship on responsible AI and AI as evidence. And then next, finally, we have Chief Judge Patrick Schultz. Judge Schultz is the Chief District Judge in the District of Minnesota. He is a Harvard Law grad and a former clerk for Justice Scalia. As relevant here, Chief Judge Schultz is the chair of the Advisory Committee on the Federal Rules of Evidence. And with that, Judge Goddard will take it away.
I could just ask the tech people to start the countdown clock. Otherwise, I'll think I have 90 minutes, 45 minutes from now. So hopefully we'll get that. You don't want that. Oh yeah, okay, we're working, perfect. And I'll just make one quick correction. Judge Schultz has stepped down from the Federal Rules Advisory Committee as the chair. He's because he served his time. So
yeah, I was stepped down, right?
Yeah, right.
my term ended.
Oh, and I think we should be more at like 85 minutes. Now you've cut off 40 minutes of my time. Thank you. Okay, so let me just set the table here really quickly. We call this new technology. We avoided AI on purpose because we weren't sure some of you would show up for another AI presentation. But we're gonna sneak it in a little bit, but that's how you're gonna see it. AI is gonna get sneaked in. You're not gonna look at it and go, wow, this is AI. It's gonna come in as some of the forms of traditional evidence that we're all used to. Emails, voicemails, video files, computer logs, database records. So the question is, what's new and different about this, and how are we going to deal with it? So our panelists are going to answer a lot of those questions, but I'm going to explain why you should be thinking about it at all. We do want interaction. So during the course of the presentation, if you have questions, I'd ask you to write them down on the cards. You can raise your hand. Judge Peterson, Judge Richland will be scanning the crowd. They'll bring them up to me. And I'm going to try and weave them into our discussion because we want to be responsive to the things that you're thinking about. So let's talk about what is new exactly. So traditional digital evidence has some sort of direct human action or automated capture of real-world events. The new evidence is created by algorithmic processes that synthesize, interpret, or generate content. The computer has now become a creator or editor. So Professor Grossman was very kind to let me use her as an example. The left is a traditional picture, a headshot, professional headshot. The person who was a photographer could authenticate it. They could testify where they were. They probably have metadata associated with the digital file that shows where it was taken, what the size is, and in the time it was taken. The one on the right is generated by an AI program, an AI tool called Aragon. And I didn't just ask it to show me pictures of Professor Grossman on the beach. I asked it to give me profile pictures based on the real pictures I sent in for her dating app, okay? Now, I do want to be clear, she is not on the market. She's very happily married, but she was, even, her husband was definitely like a good sport about this whole thing. But the question is, unlike the picture that was taken by a photographer, who authenticates these pictures? You have to be talking about the process used to generate them instead of the photographer who was there with firsthand knowledge. And so the scale is pretty amazing. These are just 8 of the pictures. Within about half an hour, I was able to generate 100 different dating app profiles. Obviously, she's trying to find a movie buff who's interested in her, a beachgoer, a traveler, all sorts of different things. So how do we start to look at these things as judges and separate them in our minds so that we can decide whether or not they can be used as evidence in court? So I'm going to turn it over to Professor Grossman to talk about the 2 buckets of information that she thinks about for AI-generated evidence.
So first I'll say I asked my husband if it would be unethical if I used one of those photos from now on for speaking. In a paper that's in your materials that I wrote with Judge Paul Grimm that was published in Columbia Science and Technology Law Review, we made a distinction between 2 types of AI evidence. One we called acknowledged AI evidence, meaning you and I agree that it is generated in whole and in part using AI. So it may be that I've used a tool, Professor Capra is being evaluated, a performance evaluation. I've used some AI tool. The tool says he's in the lowest quartile, so we cut his salary, and he decides that...
I'm always used for these examples.
Always
Maura. I don't know what's going on here?
So he challenges that, and he says the tool was discriminatory, maybe based on age, something like that. And so the question is the tool valid? Is it reliable? Is it biased? Those are the questions we're asking. It might be that I'm a litigator and I have an expert that uses an AI tool. Again, no disagreement that there's been an AI tool used to analyze the blood or the gunshot residue or something like that. Or another one that's come up recently in a couple of cases is I want to change a piece of evidence because I'm the defendant in a case and I've seen a witness filmed a shooting, except it's very grainy. And so I want to use an AI tool to clean up that graininess. And this happened in a case called Washington versus Puloka, except that the defendant's expert, who was really more of a wedding photographer type, who had used some stuff that's used to, if your hair is a little mussy, to clean it up and whatever. He couldn't explain the tool, the machine learning tool that he had used. And the court eventually, under the Frye standard, it was a Washington State case, would not let that enhanced evidence in because it wasn't accepted in the forensic community and so forth. So it may be used to do an accident reconstruction or to put you in the scene of a crime, which happened in Florida.
So I'm going to talk about, because for me, when I think about these types of issues, I need to see examples. I need to understand what we're really dealing with. Businesses are adopting AI tools at a very rapid rate. So I'm going to show you 3 examples of how they're doing it so you can get in mind of these are examples of evidence that could very likely be in front of you and you could never know that any AI was involved. And none of these are endorsements. These are just some examples. There's a DAX Copilot. I don't know if you've been to the doctor lately. If your doctor has either been speaking into a microphone using like a Dragon microphone, or sometimes they use ambient AI where it just takes in all the conversation in the room and then it filters out automatically what's not relevant. And then they use that to create your medical record. So what I haven't seen, I haven't looked for it, so let's be honest. I don't know what the standards or procedures are when doctors are using this. I don't know if that becomes part of their treatment notes without any human review. I don't know what their practice is, but it's possible. It's possible that there's human review, but it's also possible that it just goes into your file. And how accurate is that? How do you start to prove that, the authenticity of that? Amazon Web Solutions has a product that has a lot of different features that AI does. One of the things that does is it analyzes customer service interactions with that call center rep. It provides summaries of conversations between the reps and the callers. It evaluates the job performance of those reps based on all the transcripts of every call they've made. And so it spits out basically a performance evaluation of that representative. Is it biased? What are the inputs and outputs? How's it making that decision? But that is going to impact that person professionally at their job. Evolution IQ is a product used in the disability insurance realm, and it plays a role in evaluating and processing disability claims. So the new digital evidence there is any evaluations, recommendations, or decisions made by the AI tool that are related to coverage. And even if a human is involved with this process, how much did the human rely on the work of the AI tool, and how much of the end result or the decision was made by the human? How do we know the tool is valid, reliable, and not biased? So those are just some examples of kind of the easy bucket, right? The easy bucket is everyone knows this was generated by some sort of a computer process. Now, how do we figure out whether or not it should be admitted in court? I'm going to turn it back to Professor Grossman to talk about what you'll see, hopefully less, but is a little bit more problematic.
So when Judge Grimm and I were first trying to draft rules proposals for the committee, we were trying to draft one rule for both acknowledged and unacknowledged AI. In other words, when we agree and when we disagree, whether it's AI generated. And we found the second type is actually a very, very different type of animal, and the question is very different. So for unacknowledged AI generated evidence, we don't agree. One of us says it's real, and the other says, no, that's a deep fake. And this, in my view, is the much harder one to deal with, because the other is really just scientific or technical evidence, and you have the tools to deal with that. Here, we'll disagree a little in views, but I'm not.
I'm probably not even a little, but yeah, we'll get some disagreement.
I'm not convinced you do. So the unacknowledged, the question is the authenticity, not the validity and reliability and bias, but the actual authenticity of the evidence.
So we talk about the deepfake problem. Maybe, Professor Grossman, could you talk about how this type of evidence might be impacting jurors, which is really why we have to be concerned about it as judges?
So there's a fair amount of psychological research that's been done on jurors, and in particular with audio-video evidence. And I don't know if the number is 650%. It's certainly been the number that's been bandied around. But if I were to read testimony to a bunch of jury pool versus if I show them audio-video of the same testimony, the research suggests they are far, far, far more likely to remember and be impressed by the audio-video. Whether it's 650% or not, we can debate. So if I took a room of people this size, and I'm going to use you again as an example. So Professor Capra plays a gambling game, as you all do, play a gambling game on a computer in a room together. And nothing happens, no problems, everything goes fine. And then I split the room in half, and I put half the people in one room and half in the other. And in one half the room, I say, Professor Capra cheated. He pulled the card out of, his sleeve, and he was cheating. How many of you are prepared to sign an affidavit to that effect? You all look at me like I'm crazy and say, no, I didn't see that. I'm not going to sign an affidavit. We go into the other room. We show them a deep fake, like one of the pictures you saw of me, except this one shows him cheating. And then you ask the same people, how many of you prepared to sign an affidavit that you saw him cheat? And half the people in the room are prepared to sign an affidavit saying they saw him cheat, not that they saw a film of him cheat, but that they saw him cheat. And that's what concerns me about this kind of evidence, is its stickiness in perception. It's not like you can just say, strike that, and it goes away, and it's not in their memory anymore.
So Maura and I present a lot together, and I have to say, usually I'm the cheater example, so thank you, Professor Capra, for filling in for me. It's really hard to believe, I'm sure, for some people, but now, thank you for taking the hit there. You've referred to this as democratized fraud, Professor Grossman. What do you mean by that?
So not only is it at scope and scale, so in the old days, if I wanted to forge a check for Professor Capra, I needed some talent. I actually would take some time, and I'd have to look at his signature, and now I can, commit a fraud in 30 seconds. All I need is a computer and an internet access. You don't even have to spend $5. You spend $35 on those photos, but there are other tools that will do it for free. So anybody, anywhere can do this, whether they're in your jurisdiction, whether they're halfway across the world. And that's what we mean by saying it democratizes fraud. Anybody can do this now.
So I'm going to show you an example of what I did, and trust me, when anyone uses the word expert in any technology, I laugh vigorously inside, because the first IT call I made as a judge was because my printer wasn't working, and it's because I hadn't turned it on. So if I can do this, you can do this. But I went to a program called 11 Labs. I have a $5 a month subscription, and I made a voice clone of myself. It took me 30 seconds of reading the obituary of Loretta Swit, if you can imagine. And I created a voice clone, and once I created that voice clone, I can just give it the text that I want it to read in my voice. So I'm going to show you an example of this, and hopefully show you my tech savvy, because I'm a little nervous about getting the video started. Here we go.
I have no idea why I'm up here speaking. I can't tell the difference between a calculator and a computer.
I have never uttered those words. They have felt true at times, but that wasn't my voice. That was computer generated based on me reading a few lines of Loretta Swit's obituary. This stuff is very easy to access, and it's certainly something, if we were family court judges, it's a really big problem, because you get a lot of voicemail evidence that says that to support removing custody from a parent. I asked a friend of mine who's a family court judge in San Diego, and I said, "What are you doing about this?" And she said, "My best." And that's about all she can do. But we have some ways to address these things in federal court. Now we're going to turn to the federal rules of evidence, and I'm going to ask Judge Schultz to weigh in here. Now that we have an understanding of what these new types of evidence are, I want to talk about, are we ready for it? Do we need to amend the federal rules of evidence to address these types of evidence? To get there, though, I first want you to walk us through the process of what it's like to amend the federal rules of evidence. And I don't have the SpongeBob memes, but it's basically like 4 years later. But I'll let you describe the whole process.
So when we are deciding whether to amend the rules of evidence, it's important to distinguish the question of, do we have a problem, from the question of, even if we do have a problem, is the way we solve it through amending our federal rules of evidence. And when you consider that question, one of the things you have to take into account is it takes forever to amend the federal rules of evidence. I was amused a year or two ago when then ex-President Trump was about to go on trial in federal court, and we got these interest groups, reporters and so on, who came and said, "We need you to quickly change the federal rules of criminal procedure so that we can telecast this trial." There's no quickly in this process. So just to just quickly in the way I describe the process, just if you today, when we're done with this panel, go up to Professor Capra and you hand him a proposal to amend the federal rules of evidence to deal with AI-generated evidence, this is what would happen. And I'm going to give you the best case scenario and query whether the federal government is good at putting out best case scenarios. So Professor Capra would put your proposal on the committee's agenda for its next meeting. That would be in the fall of 2025. Proposed amendments almost never get approved at the first meeting they're discussed, so your best case scenario would be that the committee would say, that's a good idea, and they would instruct Professor Capra to draft an amendment and an advisory committee note for consideration at the next meeting. The next meeting would be the spring of 2026, and if all goes well, The advisory committee will approve your proposal for publication. Then it goes to what's called the Standing Committee, formerly known as the Committee on Rules of Practice and Procedure. If it will consider your proposal at its June 2026 meeting. If it agrees it's a good idea, it will approve it for publication, and then it's published. Proposed rules are published in August generally. So August of 2026, your proposal will be published for comment. The comment period is generally 6 months, so comments will be due by February of 2027. After the comment period is closed, the advisory committee will look at the comments at their next meeting, which would be their spring 2027 meeting, and decide what to do. Best case scenario, they will approve your proposal as it was published. If they start making changes, it has to get published again. So best case scenario, they approve it as published. Then it goes to the Standing Committee again. If the Standing Committee, this would be now their June 2027 meeting. Best case scenario, it approves your rule. Then it goes to the Judicial Conference of the United States, which normally considers amendments at its fall meeting. So now we're up to September of 2027. If they approve, it goes to the U.S. Supreme Court. They have until May 1st, 2028 to decide whether to approve the proposal. If they approve it, it goes to Congress, and Congress has until December 1st of 2028 to reject, modify, or defer the ruling. If Congress does nothing, then your proposal takes effect on December 1st of 2028. So it takes a long time to get a rule approved. If you hand your proposal to Professor Capra today, and if everything goes as well as it could possibly go, your proposal will become law on December 1st of 2028, 3.5 years from now. And everything isn't going to go as well as it could possibly go, because it almost never does. And especially a topic like AI, that's as controversial and as difficult as it is, you're looking more like 2029 or 2030. So you're talking about probably a 5-year process to get an AI rule into the federal rules of evidence.
So Professor Capra has served as the reporter for the committee since 1996. So you've seen a few things along the way. Do you want to add anything about the process or what your role is as a reporter?
Yeah, well, first I would say, as Pat was talking, we enacted a rule in 2023 that started in 2002. So it can be a long road.
Pretty nimble.
Dave Campbell is in the audience, and I think he would tell you that there's virtue to deliberation, that there's virtue to taking time about it, that everybody gets a chance to look at it, and as a result, the rule is the best it can be. Congress can actually directly enact a federal rule, any of the federal rules and federal rules of evidence, and every time that Congress has done so, it's been an unmitigated disaster. And so I think there's a lot to be said for the deliberate nature of the process. Maybe, limit some of the periods of it. Like, why does the Supreme Court get 8 months to do something about it? That could be narrowed, I think, but that's beyond my pay grade. But deliberate is sometimes good, I guess I would say. And the public comment has been very useful in many of the rules that we have. And so the one that we're going to talk about today, which is out for public comment, I think public comment will be very useful in terms of getting the best rule that we can. One of the problems that Judge Schultz talked about in terms of deliberateness is when you're going after technology with a deliberate process, that's a serious problem. I call it the MySpace problem. MySpace is a problem, and so you regulate MySpace, and it's gone by the time it even becomes a rule. So you have to have language that is general. It can't be specific. You can't use Facebook or some kind of. But then, as Pat and I have talked about many times, sometimes then it could be so general as not to be helpful at all. So that's the dilemma that the committee's in.
So and I'll open this up to Judge Schultz or Professor Capra, when did this whole concept of AI come in front of the committee, and what's the committee's approach been to it, both while you were still the chair, Judge Schultz, and then also afterwards?
Go ahead.
Yeah, I think I started having conversations with Maura and Paul, and also just having thought about the problems that we're starting up with AI. Gave it some thought and talked to Pat about it, and our first reaction was we need some kind of a seminar, symposium. And so we had two, actually, in 2 successive years, bringing in tech people. Maura spoke, Paul spoke, people from NIST spoke, Andrea Roth from University of California, an expert in this area, spoke, and gave the committee some kind of grounding in what the problem was and whether rules would work. So it's been a slow process because, I mean, it shouldn't surprise you that the Advisory Committee on Evidence Rules are not techies in particular. You know, there's no technical wizards on that committee. It's not made for that. So the idea is to get as much, on-the-ground information as possible. And so that's what happened. So we've been at it for 3 years now.
And just so everyone read you in on who Paul is, you probably know this, but Judge Paul Grimm, who's retired, was a magistrate judge, a district judge, and is now the director of the Bolch Institute at Duke University, stepping down. I think Judge Mueller is going to take his place eventually. But he's been Maura's writing partner and thought partner in this all along the way. Unfortunately, he couldn't be here with us. I almost wore a bald cap and a bow tie just in his honor, but he's here with us in spirit, I feel confident. Judge Schultz, now that we know nothing's going to happen quickly, that means for all the judges in the room, it is what it is, right? We are going to have to be tackling this evidence with the tools we have. So can you walk us through, focusing on acknowledged AI-generated evidence, how you would approach whether evidence falling into that bucket should be admitted under the existing rules?
Sure. So again, when we're deciding whether we have a problem and we're deciding whether we need to amend the rules of evidence to address that problem, one of the things we need to look at is, do we already have the tools to deal with the problem? And with acknowledged AI evidence, and again, that's evidence that everybody in the courtroom agrees was generated by AI. The issue is one of reliability. None of the rules of evidence directly address the question of reliability, except for Rule 702, which addresses the requirements for expert testimony. I think, though, that Rule 403 gives me the tool I need to deal with the reliability issue. Rule 403 essentially tells a trial judge to assess the probative value of a piece of evidence and then to weigh that probative value against the danger of unfair prejudice and other bad things that introducing the evidence could result in. And it seems to me the reliability, if the piece of evidence I'm considering under 403 was produced by AI, the reliability of the process is fair game. It goes to its probative value, right? The more reliable the process, likely the more probative the evidence, and vice versa. So I think that in assessing the reliability, I think that Rule 403 gives me the tools I need to do a sort of a Daubert type, and you can see the factors there on the screen, a Daubert type analysis on the evidence just using 403.
So one of the challenges with these tools, though, is it's not clear what the process is. So how is a judge supposed to address whether or not, let's say, the performance review that's generated by the computer of the call center representative is authentic or reliable, that it's the product of a reliable process? What do you need to know about the process to make that determination?
What I probably need to know is things I probably wouldn't understand. So that's the problem. And another problem with this is that what I need to know is often proprietary information. It's information that's protected by law. And so a lot of it, and what further complicates the process is often the party who is introducing the AI-generated evidence in court just bought it or paid for it and is using it, but they can't tell me if it's reliable or not. They don't know anything about it. The only person who knows something about it is, I'll call it the manufacturer or the developer. Well, the manufacturer doesn't want to give up its secrets, and it may, let's imagine it's a Chinese company that has this tool, it could care less whether the results of its process are admissible in American courts. So it's a real problem when you're talking about the parties in the courtroom can't tell you whether the process is reliable. Only the developer of the process can tell you that, and the developer isn't in the courtroom and may not be even subject to process. So it's a problem.
There's also a problem with many forms of machine learning about determining what the error rate is, because I was just thinking about this. I was traveling in a foreign country, and I used Google Translate, and wasn't that great? I mean, sometimes it's like not exactly, but is that an error? Is that an error? Is that an erroneous translation? Well, not exactly. It kind of was close. Is that a rate of error? There's a lot of data that machine learning goes through. You really can't determine the rate of error. Facial recognition, you can determine a rate of error. It either was that person or not, but it's going to depend on the AI you're talking about.
Any thoughts, Professor Grossman?
So I learned this from Professor Capra, so that there was a problem.
Talk about rate of error.
That there's a problem with using Rule 403 because Judge Grimm and I suggested that in a 2019 paper we wrote in Northwestern called AI as Evidence, and we said, just use Rule 403. If you don't trust the evidence, kick it out. And Professor Capper said to me, 403 only applies to relevant evidence. Has to be relevant. And fake evidence is not relevant evidence. So technically, at least, that doesn't mean judges won't use 403. The other issue with 403 is it has to substantially outweigh, so it really tips in favor of admissibility, maybe more than you would want. So 403 is not perfect.
But you're talking about you're talking about unacknowledged, you're talking about deepfakes. And I agree with you, 403 doesn't really help us with deepfakes. But the question was acknowledged AI evidence, like the doctor notes thing that we were shown. There, I think 403 does work.
But with the proviso that, as Maura points out, it's presumed to be admissible, right? And that might be a thing to think about as to whether that's the proper result here with some of the AI, right? Mm-hmm. Yeah.
Right.
So I know that Professor Grossman has spent a lot of time. Oh, did I do something wrong? I know that Professor Grossman has spent a lot of time with Judge Grimm making certain proposals. I want her to talk about one of the proposals they've made to address these issues, and then I'm going to open it up because I think we'll have some feedback, from Judge Schultz and Professor Capra. But go ahead, Professor Grossman.
So when we first approached the committee, and we were struggling. I mean, this was very, very difficult, and our thinking has evolved over time. But we thought for the acknowledged AI evidence that the best, we weren't thinking about a new rule, which is quite elegant and where the committee eventually went. We were looking, where can we import Daubert into a rule that already exists? And we went through all the rules and we found 901B9, which has to do with a process or a system, evidence that's generated from a process and a system. And we said, well, AI fits under that. So why don't we say that if evidence produced by a process or system, you have to show that it's valid and reliable. We wanted to use the words that were used in science, not accurate, because accurate is vague and ambiguous. It has multiple meanings, but valid and reliable. And if so, the proponent acknowledges that the item was generated using AI, then they have to, one, say something about the training data and the software or the program that was used, getting at your issue of not wanting to disclose that information. We feel it's imperative, especially if you're going to do a Daubert type analysis, and show that the AI produced a valid and reliable result in this instance. So that's what we were thinking about, because we were looking for where can we import Daubert into the rules, knowing how difficult it is to change the rules. We were looking for a place we could sort of squeeze it in to the existing rules.
So I'll open it up to Judge Schultz and Professor Capra, because they have very different opinions on whether the rules should be amended at all. And anyone want to comment on this proposal?
Let me start. Sure. So first of all, I want to emphasize again, because it's very easy to get this mixed up. We're talking now about acknowledged AI evidence. Everybody in the courtroom agrees this was produced by AI. We're not talking about deepfakes at this point. I have some concerns about this rule, but I just want to stress two of them. One is, and you'll hear me say this a couple times today, when I was in the rules process and we're considering whether to amend a rule, one of the things that I consider is if we screw this up, if we're wrong about this, just how much damage would we be causing to the federal court system? One of the concerns I have about this and virtually every rule that I've seen proposed about AI is its extraordinary breadth. Look at what this applies to. Items generated by a process or a system. That's everything. I am an item generated by a process my mother and father engaged in about 65 years ago, okay?
I didn't see that coming, but go ahead.
Everything is an item generated by a process or a system. It's every business record, every receipt from a store, every check from a restaurant. It's every recording of any kind, video, audio, otherwise. It's every text message, every email, every social media post, every website.
But it was already in the rules like that.
I know, but when you add stuff to it, the question is, what's that stuff going to apply to? Everything. And blood alcohol test, radar gun results, everything. So the only point I'm making now is if we do this, look at what we're affecting. Virtually every non-testimonial piece of evidence that comes in a federal trial. So it's enormously broad. The other thing is that concerns me about almost all these proposals, there's an exception we'll talk about later, is the general rule in federal courts is the party who seeks to admit the evidence has the burden of showing that the evidence is admissible. The party who's objecting to the introduction just has to basically say, I object. Your Honor, there's no evidence here of the training data and software to show that this receipt, this text, this capture from the Wayback Machine was the product of a reliable system. I object. And so when the rule applies to everything, when the opponent just has to basically say, I object, and then the proponent has to come back with training data, information about the software, proof that it produces valid and reliable results. If you were a criminal defense attorney, why wouldn't you just object to everything and say, where's the training data, Your Honor? And the thing is that we have some of the time that happens, like we have I do a lot of revocation hearings where somebody's alleged to have used drugs and they have a particular test and the test is held by the Eighth Circuit to be reliable and I can rely on that. But we're talking about stuff generated by computers. The software is changing constantly. So even if you have an opinion saying version 7.2 of this, that, or the other thing is reliable, blah, 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 tomorrow it's version 7.3. And then next week it's version 7.4. So I see this as potentially creating enormous problems for the federal courts. And as I've already explained, I already have a tool. If we have a genuine reliability question, I have a tool for dealing with that. It's Rule 403. So those are my major concerns about this.
So here's what I want to do. I want to turn it over to Professor Capra to talk about what was actually adopted by the committee. And then, Professor Grossman, I'm going to give you a chance to weigh in about whether you think that satisfies what your concerns were and your proposal and where you sit with that. But Professor Capra, why don't you tell us what's actually been
Sure.
what's actually moving forward?
The proposal that was on the previous screen dealt with authenticity, and when you talk about acknowledged AI, you're not really talking about authenticity, because authenticity is what you say it is, and if it's not acknowledged AI, what the proponent is going to say it's this product of machine learning. So it's really not as we've talked about, it's not the ideal place to put it. As we've talked about, the concern of acknowledged AI is reliability. Reliability is ordinarily placed in Rule 702, but if it's a machine that is it's just machine data, there's no expert involved in presenting it, 702 would not be particularly applicable, or at least because it talks about expert witnesses, and you wouldn't call this machine data an expert witness. But the thought was, the reliability issues attendant to 702 are really applicable here to machine learning evidence. And so here's what the rule is that's been proposed. What it basically says is, if what the machine data is expert testimony of coming from an individual, it should be treated under Rule 702. That should be the requirements of 702A through D. So it's to lay the Daubert 702 requirements over onto machine-generated evidence. And that rule was proposed for public comment, and it was released for public comment by the Standing Committee with a unanimous vote, but for the Justice Department. And in terms of one of the roles of the reporter is to manage the Justice Department. And I think we did a good job of that this time, but this was one failure. At any rate, it is going to be put out for public comment on August 15th, and it runs till February 15th. And the idea with this rule is to get as much comment as possible because the committee is well aware of the possibility of overbroad usage, like how to define what exactly you're trying to get at. You're not trying to get at microwaves. You're not trying to get at speaking refrigerators or thermometers or anything like that. You're trying to get at really machine learning, where the machine learns as it goes and the machine acts like an actual individual. That's what we're trying to get at. Language to do that is difficult, though, and so this limitation, this rule is not applied to the output of basic scientific instruments, is maybe not the ideal. There might be something that could be done better, and that's why it's out for public comment. Usually, as Judge Campbell would know, if it's out for public comment, there's kind of a presumption that it's going to be enacted. But the committee specifically said in its papers that this is really going to be a learning experience, and hopefully a technical learning experience. And as to 403, I just don't think 403 works in the same way as Judge Schultz does. I guess we have a disagreement there. I think you really need to bring 702 kind of ideas into this.
So, Professor Grossman, I think you got it started with your proposal, and then it morphed, and this is what the committee's moving forward with. Does this address your concerns?
It absolutely did. It imports Daubert. I wonder, do you say that in the committee note, though, that you expect the court to apply the Daubert? Because those are the right questions to ask.
The committee note doesn't talk about Daubert because it's 702, not Daubert, and that's one of the problems that we've been through, that Judge Schultz and I went through in amending Rule 702. Daubert is not actually, and everything that Daubert says is not actually quite accurate, and so 702 should be the controlling idea. But in the committee note, it does say that you're using the Rule 702 principles.
Okay, so it essentially accomplished what we want. I think it's a little more elegant and narrow than what we proposed, so we were pretty happy with it.
And Judge Schultz, do we need it at all?
He's already stated that. He doesn't get to say that again. It's not like a motion for re-argument or something easy.
I'll talk more broadly, I think, in a couple minutes about whether we should amend the rules. I certainly think you could get where I'm going with this. Here's my concerns, just the major concerns about this. One is the breadth again, and you heard. So what this applies to is machine-generated evidence, and again, that's everything. Okay, it's enormously, enormously broad. I thought Professor Capra's comments, they just highlight a problem I have with this, is he said, well, what we mean by that is, it's not like just any machine, it's machines that learn and then machines that think like human beings. All these people who want us to amend the rules of evidence to deal with AI-generated evidence, not one has yet been able to define it. Not one has been able to define it in a way. So we use words like item generated by a process or machine-generated evidence, and then we say, well, what we really mean here is the whole what we really mean by the text of the rule is not a good way to change rules. So that's one of my concerns. It's very broad, and it doesn't capture what you and I would think of as AI-generated evidence. It tries to mitigate the problem of its breadth with this last sentence. The rule does not apply to the output of basic scientific instruments. Now, every trial judge in the room should be smiling and imagining what that litigation's going to look like. Is this basic or not basic? And basic to who? I mean, among the world's 10, nuclear physicists, this is very basic. For me, it's not. And again, the technology is changing constantly. So yes, that I have this thermometer you use and it sends the results to my iPhone kind of thing, and is that basic? Well, what about when they change the software tomorrow or the day after? So that's a concern. It has the same problem I've already talked about with no threshold. Anybody who wants to object can object and put the proponent to this process.
But that's true with experts as well.
Yeah, I agree.
That's true.
I agree. And the, applying 702A through D, that's tough. We actually didn't change the rule, but we clarified the rule to make it clear. That's a tough standard, and we're now going to apply that to machine-generated evidence that if an expert had been testifying to it, it would be subject to 702. And this is a problem. I'm not saying this creates the problem, but one of the most difficult areas for us trial judges is determining, is this an opinion lay testimony or is this expert testimony? Is this something that person can testify to without being qualified as an expert or not? And it's just, again, it's not created by this.
It's not
rule,
created by
but it's a problem that's
But the alternative is that basically, if you don't have a rule like this, what you have is an incentive. Instead of calling an expert who has relied on this information, who would then be dauberted, and you would have a full inquiry into the reliability of the machine data that they're relying upon, you just introduce it directly. You just introduce it directly. Or you have a lay witness who says, yeah, I pressed the button and a thing came out. And then there is no way to analyze the reliability of it. That's the alternative. And if you're saying 403 will take care of that, I'm just not convinced that that's so. Judges don't apply 403 in the same way. Judges don't. It's a proposal that's in favor of admissibility. You would give an advantage if you don't have this rule. You'd avoid calling an expert, and you would just introduce the machine-generated evidence. And that's the concern that's being addressed.
So before we move on to unacknowledged AI, I do have a question. I'm going to answer it, and I'm going to see if you agree with me. But I just want to encourage you also, just if you have any questions or comments, feel free to write them down and raise your hand and we'll collect them. But the question was, let's just give the example of the doctor's office, and then you're in a two-party consent jurisdiction like California. Is the evidence based on captured speech admissible? Putting on my former plaintiff's attorney hat, I think one of the things you definitely want to do is have in one of those forms that you have to sign just to walk in the doctor's office that you don't read, that says that we may be recording this, and then you have consent. Do you think that, I think consent's going to be required if two parties are required. I don't see any way around that, yeah.
I was surprised because my doctor was using something like that. And you know, when you sit before the doctor comes in, sometimes you're staring at the back of the door and there are all these signs like say, we don't tolerate abuse. And if you don't show up, you're going to be charged. And he's got this little thing that says, by the way, we're taping you and we assume that if you don't object, that you've consented. And I'm saying that didn't look like consent to me.
Yeah. All right, so now let's shift to the unacknowledged AI-generated evidence. Let me ask you, Judge Schultz, as a proponent of the existing rules, what are the rules that are implicated by this type of the deep fake or unacknowledged evidence?
I'm not sure I'm a proponent of the existing rules, but I'm an opponent of the proposals that I've heard to change them. So we're now going to the question of deep fakes, and I just want to make clear up front. I have never once in my life, I've been a judge for 20 years now, I've never encountered a deep fake as far as I know. I have never had a sane party claim that a piece of video or audio or something was manufactured was a deep fake. I am only aware of a handful of cases where someone has credibly challenged evidence as a deep fake in the federal courts, and those are famous precisely because they are so rare. And I don't think this comes up a lot, and I think that's important. If it does come up, we have a rule. This is something where Professor Capper and I are not going to disagree. We have a rule that's directly on point. This is now a question of authenticity. We're disputing whether this thing was generated by AI. We are, is it real or not? Is it authentic? And we have an authenticity rule. It's right there, 901A. To satisfy the requirement of authenticating or identifying an item of evidence, the proponent has to produce evidence sufficient to support a finding that the item is what the proponent claims. So if somebody wants to introduce a video in one of my trials and there's an objection, the party that seeks to introduce it has to show evidence sufficient. Now, keep in mind, people who don't try a lot of cases, this can be a little slippery. The sufficiency standard means that as a judge, I don't find that it is authentic before introducing it. That's the preponderance standard. We call it the 104A standard. Instead, what I find is that a reasonable jury could find, by a preponderance of the evidence, that this is what it claims to be. That's the sufficiency standard. Now, we have a rule right on point, so what I would do is just apply the rule as I'm supposed to. The objection isn't that we don't have a rule. The objection by Professor Grossman and others who have concerns about this is it's a very low standard. It doesn't take a lot for it to get before the jury, and as she described, videos and visual depictions have a big impact on the jury once they see them.
Right, that's the issue. If you look at 901B5, we take your tape. All we need to do is play the tape. You bring me in, I say, yeah, that's Judge Goddard's voice. I've heard her voice in court a million times. That's definitely her, and it comes in. The jury hears it then, and they hear it, and they're 650% or 300% or whatever more likely to believe it. And therein lies the problem.
The reason you apply the 104B standard here is the thought of the original advisory committee is that the jury would be as well as capable of determining authenticity as the judge, so there is no reason to not give it to the jury. And the contrast would be expert testimony, which is under the 104A standard. Judgment there being the jury is not in as good a position as the judge to decide the reliability of the expert testimony, and so you need a higher bar. That's the difference between the 104A and 104B standard.
So let's talk about, and I think the deepfake dilemma too, Professor Grossman, is going back to the gambling issue, is once you see it, you can't, it's not like, we tell juries all the time when they hear evidence, ignore it, disregard it, right? But the psychological studies show that that's not maybe something they can do, right?
So take the situation, Professor Capra leaves a threatening voicemail. We bring in somebody
Allegedly.
who says, yep, that's him, definitely him. And then Professor Capra says, well, the metadata says, that was recorded on Tuesday at 3 o'clock, but I was having my wisdom teeth taken out on Tuesday at 3 o'clock, and I was under anesthesia in my doctor's office. I could not have left that recording. So now you've got evidence it could be real, you've got evidence it couldn't be real, and normally under 104B that would go to the jury to decide, not the judge. And that's the problem, because the jury doesn't have the tools to decide.
So let me turn it to Judge Schultz to talk about that as far as how a court could use Rule 403. And let's go back to the example where someone has created a fake voice recording of me saying that I don't know the difference between a computer and a calculator. And let's assume they can't find other corroborating evidence of that. But you have someone to testify that they've known me for 15 years, and that's Judge Goddard's voice.
Yeah,
Is that a jury question or a judge?
Well, it's, as I said, you would consider, under 901, the judge decides whether a reasonable jury could find that the voice recording is authentic, and then it's up to the jury to decide that. This is an area I don't think 403 helps with. It just, as Professor Grossman mentioned earlier, the problem is that 403 only applies, you can see it in the top line there, to relevant evidence. If something is fake, it's not relevant evidence, it's fake. So 403 doesn't apply to it. The only way I could, I don't think I've ever talked to you about this, Dan, but I think the only way 403 could play in here is
No,
that...
there is no way, Pat.
Well,
But,
here,
yeah,
see if you think this works. The judge could determine that this evidence, if it was authentic, would have little probative value.
Sure.
And the process for establishing its authenticity would take so much time that it simply isn't worth... I'm keeping it out because even if it's authentic, it has little probative value, and it would take us too much time to figure out whether it's authentic. That's about the only way I could
So
think for
confusion or delay there.
delay. Yeah.
Yeah, I like that.
Yeah.
I like that. But that's not what we're talking about. Okay, go ahead.
No, but generally speaking, the main point is 403 doesn't help us. You either have to do this through 901 or you not.
Right.
So I'm going to turn over to Professor Grossman because she has another proposal with Judge Grimm to add 901C that would address these types of situations. Why don't you tell us about that, Professor Grossman?
So what we suggested, if if the party who's challenging the authenticity of AI-generated evidence, they can't just say deepfake, 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 and it gets challenged. That would raise the problem. There'd be an incentive to say deepfake to everything. But they have to demonstrate that a reasonable jury could find the evidence has been altered or fabricated by AI. So they have to have that open heart surgery or some proof, quantum of proof, to get over the hump that it is in fact fake. Then it could be real, it could be fake, but instead of going to a jury, it would come back to the judge. But the judge would look at the probative versus prejudice. So then this is sort of giving permission to use the 403 sort of standard in this context, but we took out the substantial. So we said that it would come in only if its probative value outweighs its prejudicial effect. And our view was, this is a decision judges can make because they've made this decision in other contexts, like evidence of other crimes, evidence of prior sexual assault, things like that. So that was our thinking about that. Our concern was if you ask the judge to make the authenticity decision, well, most of them are human, so they're going to have the same cognitive deficits that your jurors are going to have.
That kind of hurt. I'm just kidding. So do you think at that point it should be judge or jury?
Excuse me?
Do you think it should be judge or jury?
I don't think it should be either of them. I think the decision then goes to probative value versus prejudice. How much damage am I going to do if I let this in? How much damage am I going to do if I don't let this in?
So Professor Capra, this came to the committee, Judge Schultz.
Yes.
The committee said no, but proposed something a little different. So
Yeah,
let's talk about where the committee is with this type of solution. Let me first ask you about that.
First, I would say that the first point is that the committee is not prepared to move on deepfakes on the grounds that Judge Schultz noted that it hasn't been a problem in the courts yet. You don't want to try and get ahead of a problem that might never occur, or maybe even advertise so that it does occur, which would be a problem too. So the committee is not prepared to go forward on this. But I thought it was a good idea, given the fact that it takes so long to amend a rule, to have something, the way I put it, is kind of in the bullpen, so that once the committee does find, or if the committee, I should say, if the committee does find that there's a torrent of deepfakes coming into court, and also that courts are not able to deal with them in an easy way, this could be a possible rule. And the idea of this rule is to keep it all within authenticity, which is the question, authenticity. That probative value and prejudicial effect somehow, I guess, bleeds into authenticity under Mora's proposal, but I don't even know how that works. Like, how does authenticity affect probative value? It's much better to separate out the two issues of authenticity and probative value. If you're concerned about authenticity, then you raise the authenticity standards. That's what this rule does. So sub 1 actually agrees completely with Mora's position that a party should not be able to get into the deepfake issue just by claiming deepfake, because otherwise, well, you know, there's no end to that. So there's a showing that they must make before an inquiry into fabrication, and it is a 104B standard. It's that somebody could believe that it has been fabricated, and the showing that could be made is myriad. Your example one, I wasn't there at the time. Another example, well, the lips don't accord with the voice, or there's something wrong with the finger there, or something like that, or some kind of metadata showing. At that point, then, you're going to have a hearing on deepfakery, shall we say, and then the question is, what's the showing required by the proponent? And it says, if the proponent meets the requirement of 1, the item of evidence will be admissible only if the proponent demonstrates to the court that it is more likely than not authentic. That is, we've been using this term throughout, the 104A standard. The judge must find it more likely than not. So the judge decides authenticity. And then finally, applicability. This rule applies to items offered under either Rule 901 or 902. 901 deals with various forms of authenticity. 902 deals with self-authentication of things that, because they are considered to be authentic, like sealed documents from the government, newspaper articles, and the like. But they are subject to deepfakery like everything else. And so the idea was to include 902 as well.
So one of the things I like about this is the showing required before everything gets derailed into whether this is fake or not. But I'm curious about the limitation to evidence created by artificial intelligence. And it reminds me, I had a case where it was a TCPA case, and it was a settlement conference, and defendants swore up and down they did not have the plaintiff's telephone number in their database, and the plaintiff had attached some suspicious-looking text. If it was generated by AI, probably a little bit harder to detect, but it was a few pointed questions, and he ended up dismissing the case. But is there a reason to limit it to created by artificial intelligence?
That's an interesting question, and I guess what I would say is one of the things that the committee is cognizant of is that obviously there was this, when social media evidence hit the courts, text and the likes, there was similar kind of calls for doing something about authenticity about it, because what about fakery? And the courts handled these matters very well, and there's a lot of law out there which says that you can't get a hearing on this by just saying it's a fake text. You have to have some kind of showing. And the concern was that if this rule applied to all of that law, there might be some disruption. I guess that was a thought. But it can be rethought. This hasn't been proposed yet. And there could be a reason to apply it to all forms of digital evidence as well.
Yeah, in Santa Clara Superior Court, Judge Pennypacker ruled on an attempt to get out of an Apex deposition by Elon Musk. One piece of evidence that was shown to connect him to the issue in the case was a video interview he had done, and he said, that could be fake. I don't know. I don't think that's me. It could be fake. And Judge Pennypacker didn't accept that, and she ordered the deposition, but this would be something where it has to be more than just like, people can fake anything, I think that might be fake.
Right.
You got to show me, like, I wasn't there that day. I never showed up at that conference. I wasn't, something to be a threshold before they derail the litigation.
That's important. I think, though, that if this rule is not enacted, that's the way courts are going to come out on deepfakes.
Yeah.
I think that's what's going to happen.
Can you put this in the context of the liar's dividend, Professor Grossman? Because maybe that type of threshold showing helps address the liar's dividend, in that they can't just rely on this general everything's fake. You have to show us that there's a reason to believe that what we're looking at in this case.
But although I really think the liar's dividend is simply the taking genuine evidence and creating question about it, which anybody could do. But I think rules like Rule 11 already deal with that. You've got to have some legitimate basis for making some argument that it's fake, and I think the courts can handle if that comes up as an issue.
To this proposal, there's a proposed committee note which has a paragraph about what's called the liar's dividend. The liar's dividend is the idea that because there's so much deep fakery out there, can't you just argue that everything is fake because you can't believe what you see? Just make that argument to the jury, for example. And I guess most immediately, that argument doesn't call to mind a rule of evidence because it's just a lawyer's argument. But I did some work on this, and there's a lot of law which, and I'm sure you know about this law, which prohibits lawyers from making arguments that aren't founded in the evidence.
Right.
And these arguments can be prohibited on that ground. There have been some cases where parties have sought to introduce evidence about how easy it is to fake something, like how to fake a text. And so that's an evidentiary question. But I think that's dealt with under 403. There's a number of cases where there was one where a defense counsel said, I'd like to show the jury how easy it is to fake texts, because the defendant had like 1,000 texts setting up drug transactions. And the judge says, well, is there any indication that your client was ever subject to any of this? And no, but I would like to show him how easy it is. And the court found that the probative value of that was de minimis, and the confusion was high. So I think there's nothing that needs to be done in the rules about liar's dividend, but to have a helpful committee note might be useful if this rule goes forward.
But my concern about this is it comes back to the court to decide. I don't know if you've seen the New York Times had 10 audio videos a couple of weeks ago, and I don't know if you did it. Just got it. You had to watch the audio video, and you had to decide real or fake. I got 8 out of 10 wrong. I sent them to a half a dozen of my friends that are judges, and all of them did worse than chance. So I don't know how you're going to make these decisions now.
That's my concern. So I like paragraph 1 a lot. I think that's exactly right. My concern is paragraph 2, and this is every single proposal I've seen on deepfakes, the solution is more responsibility on the judge. Give the judge more responsibility. And as Professor Capra said when we were discussing the 104A standard, the 104B standard, that makes sense where the judge is better at something than a juror. It makes no sense where the judge is not better. Now, when we have a deepfake challenge in court, I can see like two basic ways that authenticity would be litigated. One is technologically. People are going to get into the, I don't know what you call them, hash things or you know, the whatever. It would be a technological thing. Now, stop and think about this. So I'm the judge. I'm a 65-year-old man, which I learned yesterday is still below average among federal judges. This is the only room that I'm on the younger half of. So I'm a 65-year-old man. I still use WordPerfect.
I did not know that.
Because
But we still love you. Go ahead.
Because it's a superior product to Word, and I will debate that. I will, thank you. Word is dominant not because it's better, but because of Microsoft's market power. They basically pushed WordPerfect out.
You're digressing.
So,
And this is not an endorsement.
So-
Yeah.
all right, so I still use WordPerfect. I have 0 social media accounts. I can become hopelessly confused ordering a pizza online. Honestly, I swear to God, we did this presentation for a national webinar for the ABA, and the night before, I came one click away from ordering a takeout pizza from a Blaze in Schaumburg, Illinois, because my VPN showed me as being in Schaumburg. So I know nothing. I'm terrible about technology. A typical jury has at least a couple of IT professionals on it. They're on almost all my juries because there's so many IT professionals now. It has at least a handful of people who work with technology on a daily basis. And it has about 12 people who are younger than I am, who grew up with technology, who have spent thousands and thousands more hours on the internet looking at videos and images than I have. And why would I be better than the jury at figuring out technologically whether this is deepfake? The other way we would do it, and Professor Kappa mentioned it, is just the old-fashioned way, right? The proponent has the guy come from 7-Eleven and say, the police came, they asked for our recording of the parking lot that night. I went to our computer, I found it, I copied it to this disk, I initialed the disk, and blah, blah, blah. And the other side would say, I couldn't have been in that parking lot. I was, getting my wisdom teeth, and so I couldn't have been there. That's stuff that juries decide. That's not what judges decide. They're just as good at determining a liar from a non-liar as we are, which is why on almost all that kind of evidence, 104B standard applies. We let the jury decide that. So the entire premise of all these deepfake proposals is that I'm somehow better at finding a deepfake than a juror is. I just don't think that's true. My guess is lay people taking the New York Times quiz would have done just as well as...
I think the analog, though, is to expert testimony, which the same ideas, with the same arguments were made. After Daubert, why do judges know any more about biology than jurors? And that's a good question. And it got answered by the fact that judges become repeat players and they learn as they go and they get trained by the FJC, whereas jurors do not. And so I think that's the parallel here, it seems to me. If this is going to go forward, that would be it. The second thing I would say is, it doesn't mean that, jurors don't get this evidence. It just means they're going to get it less frequently because the judge is going to be a higher screen. So you're going to have those tech people, after you've gone over the 104A standard, you're going to have those tech people evaluating it. And to me, that's a good thing. I think that's a good thing. I firmly believe that judges are going to be better about this over time than jurors on an ad hoc basis.
And that's the question. So, the premise of Daubert is, let's be honest, is that an average judge is better able to deal with complex issues than an average juror.
Yep.
So the question is, do you think the average judge is going to be better at determining whether something's a deepfake than the average juror? If you do, then this makes sense.
That's exactly right.
If you don't, then it doesn't. And
Yep.
it's just our disagreement on the premise.
Yep, that's right.
Any thoughts on that, Professor Grossman, if you weigh in? are you and Professor Capper, have you found that magic moment of agreement, or
I
are
think
you
we're
leaning?
closer to a
Okay.
agreement on this, but I'm worried, I'm obviously in favor of the first paragraph. I'm just wondering if the second is the right question to ask, or it should be a different question. But I think it's an improvement over where we are now.
There is a proposal out there by somebody in the academy to basically you'd be crazy about this, take the entire issue of authenticity out of the jury's purview. That the judge decides when there's a deepfake issue, that the judge decides whether it's a deepfake or not. And if the judge finds that it is authentic, just instructs the jury that you're to believe that this is authentic and you're not to consider it at all. You're not to consider any possibility of deepfake. The view of the committee was that's pretty revolutionary and probably pretty awful, because the jury's going to speculate about the authenticity anyway.
Yeah, and maybe unconstitutional. even.
Actually, that's right.
So here's the question before we leave deepfakes, because I want to take us back to Rule 707 or proposed Rule 707 in just a minute. But what about other evidence to either corroborate or call into question what's been alleged to be a deepfake? So, for example, an audio of I won't say this person is, because I don't want you to know if you think this is likely or not. But an audio that said I killed my wife, for example, or I stole $1 million. Or for me, if you have one of my brothers testify, she's not very bright. She doesn't know the difference between a computer and a calculator. Or someone who knows me might say, no, she understands. I don't see her saying something like that. What about other evidence aside from just voice recognition?
Well, so that would be, under this proposal anyway, that would be in 2, that the proponent would be able to come up with some evidence that corroborates the item. And that would be part of their burden of showing that it is authentic.
But you would say, Judge Shelton, I don't want to put words in your mouth, would you say, yeah, but you can do that now? Like, if you have that debate now without this amendment, you could still have that kind of explore corroborating evidence to prove or disprove that that's authentic.
We do it.
You would do it now.
Yeah,
It's
we
just
do it.
under a
We
lower
do it
standard
now.
of proof. Yeah.
Yeah, all the time.
That's
So what about-
901B4, which calls for all sorts of circumstances and supporting evidence.
Right, judges shouldn't stop doing what they normally do, using using common sense. And I think there are 3 helpful questions you can ask. One is the evidence a little too good to be true? If it's this perfect evidence, if the original device or an original copy, the native copy is missing for some reason, and you get a nice long explanation about why it's missing. It fell in the ocean while I was fishing, and then I bought a new camera, and blah, 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 blah. You start to wonder, is this real? And I think that sort of sleuthing you still have to do now, and will often answer the question.
So let me go back real quickly to the proposed Rule 707. One of the questions from the audience was, if this proposal were to pass, what's the response to the proponent next claiming that the hearsay rules don't apply to machine-generated statements?
Well, the reason that this is in 707 is that the hearsay rule does not apply to machine-generated evidence, and that's part of the problem. And you can't cross-examine a machine. Cross-examination is a solution to the hearsay problem. Can't cross-examine a machine, and so there's a famous case in the Ninth Circuit where that was decided that. About the Google Maps and the location of the Google Maps and dropping the pin, you just can't cross-examine that, and so the hearsay rule doesn't deal with that. If there's human input into a machine data that's traceable, I guess is what I would say, that would be a hearsay rule issue, which I guess would be a separate objection.
And now I'm going to take you back, or a little whiplash here, back to proposed Rule 901C, or the one that's being considered. It's not really a proposed rule yet. Under this proposal, has it been considered that in criminal trials, the requirement of the first paragraph as applied to the defense could result in a type of burden?
It's not burden shifting, it's a burden of going forward. And it's basically what's being done now with digital evidence. So I don't think it's burden shifting in that way.
Any other thoughts on that?
No, I think that's right.
in the question, if the question of deepfake's authenticity goes to the jury, does that make it easy to use a deepfake or the possibility of a deepfake to create a genuine issue at the motion for summary judgment stage to kind of stop motion for summary judgment?
Yes, is the answer. And that's one thing I learned as chair of the Evidence Rules Committee, and I was involved as a member of the Standing Committee, and before that I was a reporter to the Appellate Rules Committee, so I've been in the rules process a long time. And one of the things I learned, I remember Dan put together a seminar on the hearsay rule in Chicago. And Judge Posner had proposed abolishing some of the exceptions to the hearsay rule, so it was on his proposals, and he showed up, and he didn't actually talk about his proposals. So fortunately, I was there, and I basically made arguments that we could basically just abolish the hearsay rule and just handle everything under 403.
There you go.
Right.
403.
And
Yeah.
I was trying to be interesting. But what the voracious opposition was big firm lawyers saying this would make it harder for us to get summary judgment. This would make it harder for us to get summary judgment. And I started to realize how much of the rules of evidence, the comments we get when we propose changing them, how much of it is by lawyers who just they just really don't want to try cases, and they really, really are concerned about the impact on our ability to get cases dismissed on Rule 12 motion or on a Rule 56 motion.
Well, that's what Rule 702 is all about, that whole fight, right, from the
Yeah.
defense bar.
Yeah.
Right? They wanted those experts excluded, and then what would happen after the experts are excluded? Summary judgment.
Yeah, big cases and big firms and their desire to get summary judgment play an outsized
Drive a
role
lot.
in the rules process.
And that's an interesting segue to the next question, which is also in the minds of a criminal defense perspective. Would subsection 2 here, the showing required by the proponent, implicate the Sixth Amendment right to present a defense?
I'm sorry, I just didn't hear the end of your.
Well, would the sub 2
yeah.
there, would it implicate the Sixth Amendment right to present a defense in a criminal case?
I don't know how lifting the burden from B to A is that much of an incursion. I tend not to think so. It would be a pretty strained argument, it seems to me, because all you're doing is applying a higher standard to one piece of evidence, and the justification would be this is evidence that's much harder to deal with than your ordinary form of evidence. Assuming that's true, then I think that would be rejected. But
I mean, we do this. I mean, we do this in expert testimony in criminal trials.
Right.
And I think when you got to the proposal that Professor Capra mentioned, where you're instructing the juror that they must consider something authentic, I think there we have a problem.
For sure.
That's why with judicial notice in criminal cases, you don't tell the jury they must accept what the judge has judicially noticed. But I don't think this type of proposal.
a criminal defendant has a 104A standard to meet with most of the evidence that the defendant presents, so I don't think that this would be a problem.
I have heard public defenders, though, say that their access to experts is far less on the criminal side than the government has access, and they feel so outgunned there when there is this battle of experts.
That's absolutely true, but that's not a thing that the rules of evidence can take care of, I don't think. That's a resource problem.
Oh, and aren't we feeling it? I want to turn to some things that the courts can do now. The first thing is building time into the schedule, to the case schedule, to address these types of issues. In the written materials for this program, you have the Southern District of California. We've developed a Rule 26 checklist that all the magistrate judges have adopted because we handle the initial scheduling conferences in our district. And it specifically says the parties have to discuss whether they intend to present any evidence that's created or enhanced by a Gen AI tool at trial, such as video enhancement or scene reconstructions, and whether specific deadlines should be set in the case schedule for challenging the admission of such evidence. Because it's really disruptive to the schedule if this comes up at motions in limine. There's almost nothing you can do about it. Because one of the big questions that comes up is whether you're going to need additional discovery. And maybe, Professor Grossman, you can talk about, I know you do a lot of work as a special master, what type of additional discovery this might open up when someone cries deep fake, or even just says, I challenge whether or not the acknowledged AI-generated evidence is reliable.
So if we're going to get into experts, which I think we are going to get into experts a lot in this area, your expert is going to want to know about the training data, is going to want to know about the source code, or is going to want the original device that was used to record the audio video. So it's going to be much more intrusive discovery than we're used to. I mean, normally, unless there's some allegation of fraud or destruction, spoliation, something like that, you don't normally get into, produce the entire phone or give me the source code and stuff like that. And I think with experts and with right now the fact that the technology that's available to distinguish real from fake is not robust and not reliable enough to count on, that we are going to need experts to get their hands on the actual devices, the actual data, so that they can look for discrepancies.
Did you hear the cash register? Cha-ching, cha-ching, cha-ching. It's going to be expensive. And obviously, confidentiality is an issue, but protective orders can do a lot and take you pretty far in addressing those types of issues. So I do want to focus our last few minutes on experts. I want to turn it to you, Judge Schultz, but we got a question from the audience going back to the proposed Rule 707. In that rule, can you only use experts? Or what if a lawyer could just argue that it meets the requirement and do so persuasively?
You mean as to whether something is reliable?
The machine-generated evidence.
Boy, that would be hard to do without an expert, I think. The reliability of acknowledged AI.
Oh, yeah, I don't think you could. I mean, maybe there's some published data or something you could introduce, but I would think you'd need an expert.
Even then, you'd need an expert to say the data is still valid, or
Yeah, you're probably going to need an expert.
I think the answer is no. You couldn't do. Again, we're talking about acknowledged AI.
Right.
I don't think you could do it without an expert.
Yeah. I think with some of these tools, what you'll find is they're going to become so ubiquitous that people aren't going to challenge it. They'll just accept it as reliable to a certain extent, but not in every case. So you
Right.
might have to. But Professor Grossman, what does it look like as far as the type of evidence that's going to show that the tool is reliable? Is it the internal testing? Is it let's say for the medical record software that they've done some internal testing to show that it accurately transcribes the meeting or filters out the small talk internally, that they've done that as a company?
Well, are you talking about for the deepfakes or for the?
I'm talking about for the acknowledged AI.
I think the point is, you don't always have to show how it works. I mean, I'm going to get in an airplane after we finish, and I have no idea how it lifts or anything else. But I get on it because it's been tested and validated independently. So I think for some of these tools, if somebody can come in and answer essentially those Daubert questions, was this tested? Was it tested by somebody independently? Has it shown to be valid and reliable? What's the error rate? Is it biased? And if somebody can answer those questions, then explainability becomes a lot less important.
Any other thoughts on that? What types of information you think that the courts might get to verify these tools?
Well, I guess one of the problems of explicability is what you're talking about is even the people who develop some of the machine learning don't know how it works.
Yep.
So that's going to be a problem for courts to have to deal with if it comes up.
But we don't know how certain drugs work in our bodies, and we take
That's
them
true,
because
too.
the FDA
Yeah.
has said it's okay and has tested them. So
Yeah.
I think we're going to need, I've always said, why don't we have an FDA for algorithms? Where they could be independently tested and given not all of them, but it's certainly ones that have huge impact on people or that are going to appear in the courts over and over.
So Judge Schultz, as far as expert testimony, maybe you could comment on ways to use it because under the existing rules, to verify or to assess these types of issues about whether evidence should be admitted.
Well, one thing I've done, so I've only done this, I think, 3 times, and I've been a judge for close to 20 years, Rule 706, right, allows us to use court-appointed experts. And I've had 3 cases where I've used court-appointed experts where things were just so complicated, I just couldn't understand them. I needed my own tutor, basically. And I could see that being an option here.
Did that person then become a witness?
Yeah, the way I've always done it is, the parties usually agree on the expert, and I appoint the expert, and I ask them usually the questions I want asked, or they'll do a report, and everything is open. There's no private communications, and the expert comes and answers questions in court, and they're my questions, they're the parties' questions, and it's like having a tutor. And I found that I had a patent case involving lines of code in a program. I mean, I didn't even speak the language. And I had another case involving an international tax case that there was 6 of them around the country, and they tried to make an MDL out of them, and they couldn't find a judge who would take it because it was so complicated. And it was just, we got a tax professor from Georgetown who was just like a tutor to me and helped me work my way through it. So
Who paid? Who paid?
In all those cases, they split it, but they were all civil cases.
Right.
In a criminal case, I think the government pays. I haven't used one in a criminal case.
Any thoughts on that? Any other thoughts on that, Professor Grossman?
Well, Judge Grimm has done something creative. He did it in the Marriott data breach case. He didn't want a 706 court-appointed expert. He wanted help, but he didn't want the person to tell him how to rule or anything like that, just to help him understand what questions to ask himself. So he got a technical advisor that served as a tutor that was private, so he could ask his questions, how does this work, or what should I be asking them? You don't like
The problem with that is the ex parte nature of all of
Yeah,
that,
that's-
right? And then you see the opinion written, and it doesn't sound like that judge. I'm not talking about Paul Grimm, but I'm talking about some other, who wrote that. I mean, that's the concern.
Yeah,
right?
I've heard of judges doing that, but you'd have to get the parties' consent. And in a
Right. He
high-stakes
didn't,
civil
yeah.
case, they're not going to let an expert talk to you and not know what the expert's saying
Right.
to you. It's-
And
So I'm going
then-
to give you each like 30 seconds for a final takeaway, but let me start with that on my own. I do teach a lot of new technology and AI to judges around the country, and if anything I can impart with this panel is, it might seem scary because you just hear about it and it seems a little bit weird and different, but it's manageable. I mean, I think hopefully that's a takeaway from today, that we have rules in place. Whether we need to fix them down the road is a different issue, but it's manageable. This is something that I think we're well equipped to do. Any other thoughts? You can disagree with me on that, but you're telling a whole room of judges that you don't think they're well equipped to handle this. But go ahead.
Agreed.
I'll start with you,
completely.
Professor Capra.
So I guess I would say, just to go back to 707, it is coming out for public comment, and we really invite a lot of public comment. I'm hoping it's going to be constructive, like a comment which we often get, I can't believe you did this. Not going to help. This is not a rule that is seeking that kind of comment, because we know there's problems with the rule. Just how to solve the problem, the breadth of the rule is really what we're trying to get at. And also, I mean, the Judge Schultz problem of, do we even need a rule? Those are 2 questions that I think would be useful to understand. And if anybody's got any tech information or knows anybody's got any tech information, we invite comments.
Professor Grossman.
I worry that Judge Schultz is not going to be right, that this is going to be a problem. I hope he's right, that this isn't going to come to your court any day soon. But if he's not right, I'm not convinced you have all the tools you need right now to deal with this.
Judge Schultz, you get the last word.
What I would say is, when a hot new issue comes up, there's oftentimes a lot of momentum to write a new rule. There's a professorial think tank, bar association, industrial military complex out there that when there's a hot new issue, they swing into action, they talk to each other. These are very smart folks who get paid to identify cutting edge issues and write papers and hold webinars, and it's very, very valuable work. I don't mean to, Judge Grimm and Professor Grossman deserve enormous gratitude from the federal judiciary for putting this on our radar, so we're looking at it. But I don't think we should move now to amend the federal rules of evidence. As best as I can tell, almost all the pressure now to amend the federal rules of evidence to deal with AI is coming from scholars. It's coming from think tanks. It's not coming from judges. Aren't raising these concerns. trial lawyers, by and large, I don't mean there aren't exceptions, but by and large, trial lawyers aren't raising the concerns. It's coming from the professorial class. And for now, I believe we should resist this pressure. I've mentioned a number of reasons why, I won't repeat them. I think we should follow the path that we did with social media when we were afraid everybody's just going to say their account has been hacked, and what do? And judges, we used our existing tools to deal with it. I don't think there's any pressure now to amend the rules to deal with claims of social media hacking, except insofar as it's considered a subset of deepfakes. And so I would just caution patience at this time. I would like to see this play out, and I would like to see real problems emerge before we pass sweepingly broad new amendments to the rules of evidence.
All right. On behalf of the Magistrate Judge Education Committee, we want to thank Judge Goddard and the rest of the panel for this great presentation. Thank you.